Governments are sitting on billions of dollars in unclaimed money. But what happens when that money belongs to a family trust? Well, today we're going to pull back the curtain on the specialized companies that actually find these lost funds and break down the exact process they use to get it back to its rightful owners. Okay, so just imagine this. You get a call completely out of the blue. Some company on the other end says they've found $50,000 that belongs to your family's trust. It sounds almost too good to be true, right? But believe it or not, this actually happens. So how in the world does this process even work? So it all kicks off with the discovery phase. And this isn't just about getting lucky. It's a really methodical hunt for assets that have somehow fallen through the cracks over the years. Okay, so first things first, these companies audit government accounts. They're sifting through records, looking for any excess funds where a trust is listed as the former owner. Once they get a hit, they pulled a property deed. And that deed is the key. It's the document that helps them find the person who created the trust in the first place, and that usually leads them right to the person who's currently in charge, the trustee. All right, so once they've found the trustee, the next big hurdle is a legal one. The question becomes, who actually has the authority to sign a deal and claim that cash? And this is absolutely crucial. You have to understand the difference between a trustee and a beneficiary. The trustee is the legal representative, the one who manages the trust. The trustee, and only the trustee, has the legal power to hire the company and sign that agreement. The beneficiary, who's the one that will eventually benefit from the money, well, they actually can't legally sign on the trust's behalf. Okay, but what happens if the original trustee has passed away? Well, that's when they have to dig up a copy of the actual trust document. They need to see how a successor is supposed to be appointed. And if nobody is named in the document, a court might have to step in and appoint a brand new trustee before the claim can even move forward. All right, so we found the right person. Now it's time to talk about the contract. Let's really break down this fee agreement and see what's promised on both sides. So on their side of the table, the organization is basically promising to do all the heavy lifting. This means they'll fund all the reasonable costs, they'll do all the work needed to get the funds back, provide all the paperwork, and they'll even hire a lawyer if things get messy. For all intents and purposes, they become the trust's exclusive agent for this whole recovery effort. Now, in return for all that work, the trustee has a couple of key things they need to do. They've got to agree to cooperate fully with any requests, and here's a really time-sensitive part. They have to sign and return all the necessary documents within just 3 business days. And that same quick turnaround applies when they get the final payout proposal, too. Okay, now we're getting to the part everyone's been waiting for, the payout. If the claim is successful, how does the money actually get divided up? The whole deal hinges on something called a contingency fee, and it's a really powerful idea. What it means is the organization takes on all the risk. They only get paid if and only if they successfully recover your money. If for some reason the claim doesn't work out, the trust owes them nothing, zilch, nada. The company just eats all those upfront costs. So what's their cut? The fee for this service is a set percentage. The organization takes a 40% fee from the net amount they recover, which means your trust is looking at getting the other 60%. But listen up, because this is a really critical detail in how they do the math. Any expenses the company paid out of pocket, we're talking notary fees, delivery services, things like that, are paid back from the total amount before they do that 60-40 split. This definitely affects the final amount that gets divided. Let's walk through a quick example so you can see exactly how this plays out. Say they recover $10,200. So the first thing that happens is they take out their $200 in expenses. That leaves a nice round net amount of $10,000 to split. The trust gets its 60% share, which is $6,000, and the organization gets its 40% fee of $4,000. Pretty straightforward. Of course, with any contract, you gotta read the fine print, right? There's one key clause in here that's designed to protect all that upfront work the recovery company already did before they even found you. And that protection comes from something called a non-circumvention clause. Basically, in plain English, it's an agreement that says the trustee won't just take the information the company gives them and then try to go around them to claim the money on their own, cutting them out of the deal. And the thinking behind this is that the company's real value isn't just in filing a few forms. Like the contract itself says, a huge chunk of their effort, all that auditing and detective work to find the right person, is already spent before you even get that first phone call. And finally, let's just quickly touch on a few other standard but still important terms you'll find. First, the trustee has to give a warranty. That's just a fancy way of saying they formally promise they have the legal right to this money. The agreement also lays out that any legal fights will be handled under Pennsylvania law, which is probably where the company is based. And lastly, it's a binding agreement, meaning it applies to any heirs or successors, so the deal stays in place even if the trustee changes down the line. So now that we've walked through this whole process, it kind of leaves you with a final thought. If you were that trustee, if you got that call, what is the very first thing you'd want to double check before you even thought about signing on that dotted line?